Okay, let's unpack this. We are diving deep today into a truly fascinating idea from a brand new book. It challenges something many of us, maybe especially those steeped in law or moral philosophy, just, well, assume is true. The big question is, do wrongs and rights always go hand in hand? We instinctively think they do. You know, if someone wronged you, they must have violated a right you held. But what if that connection isn't always there?
Right. And our instinct, and certainly the traditional view, particularly in legal thinking, is that they must go together. The logic feels, well, simple. No right of yours violated means no wrong to you. You might be affected, maybe harmed, sure,
Mhm.
but you aren't the specific target of a wrong in that relational sense.
Like Justice Cardozo's famous opinion in the Paulsgraf case, right?
Yeah.
Women injured on the train platform.
Exactly. The falling scales, the passenger with the package. Cardozo said Mrs. Polsgraf couldn't sue the railroad. Why? Because their duty of care in that specific context was owed to the passenger with the package, not to her.
Ah, okay, so the duty wasn't directed at her.
Precisely. His core claim was explicit. Agent X wrongs Y only if X violates Y's right, meaning breaches a directed duty, a duty owed specifically to Y. He even suggested rejecting this idea would lead to utter confusion, requiring, and this is a quote, life will have to be made over and human nature transformed.
Wow.
Yeah.
That's strong. Like, you can't even question it.
It seems axiomatic to many, yeah, like a fundamental law of the moral universe you just can't change.
Okay, so our mission in this deep dive is to challenge that axiom using the compelling arguments and examples from this new book. We're going to unpack the argument that actually, contrary to Cardozo, rights and wrongs often do come apart.
Mm-hmm.
And we'll explore why separating these concepts isn't just academic nitpicking. It actually helps us understand moral life, you know, everything from legal cases to personal relationships in a much richer way. Our source material for this dive is just the excerpts provided, but they give us plenty to explore.
So the book's central thesis is basically this. Are ex-ante normative relations, those things that exist before an action, like having rights or being owed directed duties.
Right, the before picture.
Yeah. Those don't map straightforwardly onto our ex-post moral relations. Those are the relations that arise after an action, like having a complaint against someone or, having been wronged by them.
The after picture.
Exactly. The argument is that there are two distinct moral phenomena at work here. Our accountability relations after the fact aren't simply the automatic flip side of entitlements beforehand.
Okay, I get the before and after idea, but as the source material asks, why isn't this just a semantic argument? Just, arguing about the words wrong and right.
Because it's about substantive moral practices and experiences. It's about how we actually live and interact. Think about it. If wrongs only exist where a specific right of yours was violated, it dramatically reshapes our moral landscape. Well, it dictates who has the moral standing to complain, right? Who owes apologies, how we understand personal responsibility. The source argues that if someone clearly harms you, maybe injures you, but you don't have a specific prior right that was violated, say you're a third party, not directly addressed by the initial duty, denying that they wronged you feels intuitively wrong. It feels off. It suggests you're morally just like any random bystander, even if you were directly injured. That denial feels like it misses a crucial part of the relational moral picture.
That makes a lot of sense. It moves it from just abstract definition to the real world feeling of being personally injured by someone else's actions. So what are some of the examples the source uses to really drive this home? These cases where someone seems clearly wronged, but without a clear prior right being violated.
Yeah, there are some great ones. One of the most powerful illustrations comes from literature. Tolstoy's War and Peace. Remember the story of Natasha Rostova and Prince Andrei Bolkonsky? They're engaged. He goes away.
Right, and while he's gone, Natasha falls for another man, breaks the engagement to elope. A classic betrayal.
A clear moral wrong, right? She betrayed him. Absolutely. And the book emphasizes that both Natasha and Prince Andrei experience it this way. Natasha is tormented by the wronggress. She feels she has done him specifically and begs forgiveness.
And he feels wronged.
Deeply, deeply aggrieved, personally wronged. Yet, and this is the key point the source highlights from the novel, Prince Andrei himself notes that Natasha was and is perfectly free. He had no right to her commitment, her love, or her hand in marriage in the way a right holder controlled another's actions.
She was free to change her mind.
Exactly. She was free. Despite this lack of a formal action-shaping right, the wrong clearly exists, it's palpable, and it's central to their tragic interaction.
Wow. So the insight there is that the wrong wasn't about breaking some former rule Prince Andre could hold over her,
Right.
but about violating a kind of relational expectation that generated a personal grievance even within her freedom.
Precisely. It shows the moral reality for the people involved wasn't dictated solely by those formal rights. Now, what about those third-party cases you mentioned? The source calls them a gateway to seeing this distinction.
Yeah, tell me about those. How do they work?
Well, these cases often highlight the distinction because the injured party wasn't the person the original duty was primarily directed towards. Take the example from Jane Eyre. Mrs. Reed, Jane's aunt, confesses on her deathbed that she wronged Jane in two specific ways.
Okay.
First, by breaking a promise she made to her husband, Jane's uncle, about raising Jane well. Second, by lying to a wealthy relation who was looking for Jane.
So Mrs. Reed broke promises, okay, but not promises made directly to Jane herself.
Okay.
Jane wasn't the promisee in either case.
Exactly. Jane wasn't the direct beneficiary of the promise to the husband, and she didn't have a specific right that Mrs. Reed tell the truth to that relation. Yet Mrs. Reed recognizes she wrongs Jane. The key insight here is that the recipient of the wrong isn't necessarily the holder of the directed duty that was breached.
So your stake in the situation, even if you're technically a third party, can mean you're the one who's wronged.
That's the idea. Your stake can create the possibility of being wronged, even without that initial direct duty to you.
And our legal systems seem to struggle with this, right? Because of that Cardozo-like axiom. The source mentions contract and negligence cases.
They do. Cases like H.R. Mochco, the water company failure causing a warehouse loss, but the warehouse owner wasn't party to the city's contract.
Right, I remember that one.
Or Ultramares Corp., the investor relying on an accounting firm's certification meant for a different client and suffering loss. In these situations, courts applying a strict no duty owed directly to you, no wrong to you rule might just deny liability.
Which feels wrong.
It can feel really wrong. The source uses these to show how that strict axiom seems to deny obvious grievances experienced by third parties. Even though a complaint like, hey, you shouldn't be negligent in your work where others might foreseeably rely on it, can arise without the full force of a claim right held by that injured party.
What about more personal relationships? Like harm to loved ones? That feels like a really common scenario where someone is clearly wronged, but maybe they didn't have a formal right that the other person not harm their loved one.
Precisely. That's another area where the common law really shows this tension. Traditionally, you could only sue for violations of your own rights. This makes it legally awkward sometimes to fully address the moral intuition that someone like a parent is wronged when their child is gravely injured.
Yeah, the harm feels direct to the parent, too.
It does. And legal doctrines like loss of consortium or emotional distress claims have evolved partly because that moral sense is so strong, we are wronged when someone injures our loved ones. The source quotes Leonardo in Much Ado about nothing feeling Claudio wronged mine innocent child and me, illustrating how the parent feels the child's injury as a direct wronging to them.
So it's a wrong through the child to the parent.
Exactly. Because of their stake in that relationship. It's not just the child's wrong, it's also the parents.
It seems like this extends even further into things we might not think others have a right about, like our own life choices.
Absolutely. The source highlights how others can have a significant stake in the important choices we make in our lives and feel wronged if we make certain decisions, even if they have no right to control those decisions. Think of the poem mentioned about the farmer whose son chooses not to farm. The father feels a loss, a specific kind of wrong related to his hopes and their shared life.
Even though he knows he can't force his son.
Right. He knows he has no claim to the son's obedience or career choice, or that powerful scene in Good Will Hunting. Chucky tells Will that he doesn't owe it to himself to take a better job, but implicitly he owes it to Chucky, to their friendship, their history, not to waste his potential.
Yeah, I remember that. Every day I come by your house and I knock on your door and we go out. And that's okay. You know why? Because I'm thinking, maybe you're gone.
Exactly that feeling. Chucky feels Will is wronging him by staying, even though Chucky has no right to dictate Will's career path. The wrong arises from the shared life and the stake Chucky has in Will's choices, not from some prior right to control Will.
Okay, so we've seen these compelling examples where wrongs seem to exist independently of prior action shaping rights. If they're not the same thing, then what are rights and wrongs like? What are their distinct natures according to the source?
Good question. The source describes their key features, trying to tease them apart. Rights, first off, are fundamentally action-shaping. They operate ex ante before the action happens.
Shaping actions beforehand.
Yeah, Having a right creates a direct pull on others' choices before they act. It kind of excludes certain ordinary considerations from their deliberation. The source uses this metaphor. Acting against a right feels almost like looking into the sun, something you practically cannot do, because the right holder exerts a kind of direct control or authority over your choices from that prior ex-ante perspective.
So they tell you what you absolutely mustn't do, or what you must do before you even do it. They limit your options.
Exactly. They narrow the morally permissible paths you can take right from the start. Wrongings, on the other hand, are primarily about accountability and are understood ex post after the action has occurred.
Accountability after the fact.
Right. Being wronged gives you a special moral standing after the fact, the standing to complain, to resent, maybe to forgive, and so on. For the person who did the wronging, it involves a kind of directed guilt towards an identifiable person. The source suggests this standing is unique and isn't simply reducible to having, say, a second-order right, like a right to an apology, particularly if that supposed right didn't have any practical force in shaping the action beforehand.
And the book argues that potential wrongings, the ex post stuff, are comparatively inert in shaping action ex ante, unlike rights. How does that work?
Yes, that's a crucial point illustrating their distinct natures. Consider a warranty, okay? Like a roofer gives you a warranty that the roof will last 20 years. If it fails after 5, you are clearly wronged, you have a grievance, the roofer owes you a remedy.
Makes sense.
But the source argues this potential ex post wronging doesn't necessarily mean the roofer had a strict ex ante duty to make the roof last 20 years, especially if external factors like a freak storm were involved. Their action-shaping duty might only be to build it correctly using standard practices, or, crucially, to stand by the warranty if it fails.
So the duty is more about the remedy than guaranteeing the outcome itself.
Often, yes. The wrong exists, you have a grievance, and are owed repair. But it wasn't necessarily based on a direct action-shaping duty to guarantee the outcome beforehand in the way a directed right absolutely prohibits an action. The promise creates an accountability relation if something goes wrong, but maybe not a strict duty to succeed beforehand.
Okay. What about the other examples, the sexual promise?
Right. A more personal and sensitive example discussed. Jane promises John she'll have sex with him. If she breaks this promise, the source suggests she might wrong him, he could have a complaint, she might feel she owes an apology. But this potential ex post wronging doesn't function as an action-shaping duty in the same powerful way a typical directed duty would. Her decision whether to actually have sex shouldn't, and arguably couldn't morally, exclude her own desires, feelings, or reasons from deliberation ex ante.
Yeah, that seems right. Her autonomy matters in the moment.
Exactly. The grievance exists if the promise is broken based on that prior commitment, but it doesn't operate with the same kind of preemptive, choice-constraining force as, say, a right not to be assaulted would.
And avoiding future regret. That's another example of this ex post perspective not being action-shaping.
Precisely. Choosing to act a certain way just to avoid future regret, that potential ex post feeling, is essentially using a proxy, kind of looking in the rearview mirror.
Yeah.
It's not seen as a fundamental, action-shaping, justifying reason for action in the moment, unlike deliberating based on present duties or the rights of others. This highlights how wrongings, being focused on accountability and consequences ex post, don't inherently have that same immediate, action-shaping power ex ante.
Okay, so they're distinct. They operate on different timescales, different functions, action-shaping versus accountability. That makes sense. Where do they intersect and diverge in more complex scenarios? This gets tricky, I bet.
It does. The distinction helps us understand practices like moral repair, though. Things like apologizing or offering compensation. These practices are responsive to the wrong suffered, which can vary significantly in magnitude and even form based on the resulting harm and, crucially, the victim's experience of that harm. Even the initial rights violation might be described identically in two cases.
Can you give an example? How would the victim's experience change the repair needed?
The source uses the example of Anna leaving Alexei from literature again. If he experiences the breakup primarily as losing a shared future they were actively building together,
Right, the plans, the hopes.
then her apology might appropriately focus on that loss, on letting down those shared expectations for the future. But if he experiences it differently, maybe he quickly finds happiness elsewhere, but now looks back and bitterly regrets wasting years on Anna.
So the injury isn't the leaving itself anymore, but the time lost before.
Exactly. Then her appropriate apology might need to shift. It might be less about leaving when she did, and more about ever making the promises in the first place, about contributing to wasting his past. The form of repair, the apology's content, is dictated by the ex post injury and the victim's specific experience of it, not just by some abstract description of the ex ante right or promise that was violated.
That's a really powerful insight. The wrong isn't just the act, but the consequence and how it subjectively lands. What about actions that wrong others but can't be claimed as a right? The source calls this the unclaimable.
Yeah, this explores moral duties that exist but aren't correlative with claim rights. A claim right is basically a right that the holder can, demand be fulfilled or enforced. Beneficence is one example discussed. While maybe not strictly required as a directed duty to a specific someone in many cases, failing to be beneficent due to perverse or malicious reasons can still feel like it wrongs others who were perhaps counting on it or deserved better.
Like kicking someone when they're down, even if you didn't strictly owe them help.
Sort of, yeah. Or abuse of rights is another clear one. You might have a legal right to do something, like firing an at-will employee. The law allows it. But using that right in a clearly malicious way, solely to harm them, like the example given is firing a salesperson right before a huge commission payout just out of spite that wrongs the person.
Even though they had no legal right not to be fired?
Exactly. They had no claim right against being fired in that situation. You had the legal discretion, but you're still morally accountable for abusing it in a way that creates a legitimate grievance. You had the right, but you committed a wrong in how you exercised it.
Okay, so the motivation matters for the wrong, even if the action itself was legally permitted. What about gratitude?
Gratitude is a fascinating case, too. We feel someone ought to be grateful, right? And failing feels like a serious moral lapse, a blackest ingratitude. It feels like a duty.
Definitely.
But, as the source notes, the benefactor cannot claim or demand gratitude. Demanding gratitude actually undermines its very nature. It has to be freely given. So it's a duty owed. Failing to meet it wrongs the other person, but it's not claimable as a right. It highlights a duty without a correlative claim right.
And thoughts. The source argues even thoughts can wrong someone. That seems like a really big leap. How can a thought wrong someone?
Yeah, that really pushes the boundary. The source argues things like harboring malevolent fantasies about someone you're close to, or maybe failing to remember a loved one as you promised you would.
Like forgetting an important anniversary on purpose or something?
Maybe even just letting the memory fade when you promised to keep it alive. The argument is these can constitute a relational wrong. They could elicit personal resentment from the other person if discovered, and might call for apologies from the person who had the thoughts or failed to remember, indicating a grievance has occurred between them.
But that doesn't mean we have a right to control what others think.
Absolutely not. The source is clear on that. This doesn't imply a moral right for someone to control the thoughts of others. The inherent connection between rights and the power of claiming or control prevents that inference. The wrong, if it exists, lies in the nature of the thought or the failure to remember within the context of a specific relationship, not in violating some right the other person had to dictate your internal mental life.
Okay, that's subtle. Now for the flip side. The complaintless. Can someone have a right but somehow lack the standing to complain when it's violated? That also seems counterintuitive. If my right is violated, shouldn't I always be able to complain?
It does seem counterintuitive, but the source presents several instances where this might be the case. Consider someone who throws the first punch in a bar fight.
Okay, they started it.
They violated a norm, the duty not to punch. If they then get punched back, the source argues they might lose the moral standing to complain about being punched. Why? Because they violated the very norm.
Yeah.
Don't initiate violence they would need to implicitly invoke to assert their complaint against being punched back.
You can't really appeal to a rule you just broke yourself.
Exactly. The duty not to punch might still exist universally, maybe it's owed to everyone generally, but their individual complaint based on that duty is lost or undermined by their own prior action.
Okay, that makes intuitive sense. What else?
Another case is when violating your right ultimately benefits you, and you actually endorse it with hindsight. Imagine someone breaks into your house, clearly violating your right against trespass. But it turns out they did it because they spotted a fire inside, and they were pulling you out, saving your life. Even though your right against trespass was violated, from an ex post perspective, looking back, you might feel you have nothing to complain about.
Yeah, you'd probably thank them.
Right. The outcome was overwhelmingly positive and aligned with your deeper goals, like survival. The lack of complaint stems from that ex post assessment of the total situation relative to shared goals, not from the absence of an initial rights violation.
And controversially, the source discusses animals in this context
Mhm.
as potentially having rights but being complaintless.
Yes, this is a challenging part of the argument. The source argues that animals have rights, meaning duties are owed to them regarding their welfare, directed to them as beings who matter morally. But they are complaintless in the specific human sense of being able to formulate a grievance, demand justification, hold us accountable through reasoned argument, or claim their rights using language.
So they can't complain like we do.
Right. And this challenges theories that tightly link having rights to the capacity for accountability or demanding justification. The argument is that seeing the emotion in an animal's eyes, recognizing their suffering or joy, evokes a direct relational response that goes beyond simply valuing them instrumentally. It's recognizing them as beings to whom duties are owed, even if they cannot formulate a complaint in the human way. So, on this view, you can have a right without the capacity to complain about its violation in that specific discursive way.
So rights aren't necessarily tied to being able to assert them or complain when they're violated. That changes the definition quite a bit, focusing more on the duty owed to the being.
It shifts the focus away from the capacity to claim as the defining feature of having a right. Yes. Finally, the book looks at the distinction between waiving complaints and waiving rights. Can you forgive someone before they've even acted?
Like, I forgive you in advance for whatever stupid thing you're about to do at the party. That sounds odd. Does that even work?
Laughs slightly. Maybe not as real deep forgiveness, but the source explores the idea structurally. Telling a spouse, maybe seriously, look, I forgive you now if you happen to get drunk at the conference.
Mm-hmm.
This doesn't necessarily give them permission, right? The duty not to get drunk might still exist based on other factors like shared commitments or health,
Okay.
but it functions as a waiver of your complaint regarding that specific future act. This shows you can potentially retain a right, perhaps against them breaking a promise about drinking, rooted in a broader commitment, while giving up your standing to complain if it's violated in that instance. It's framed as a release or waiver of the complaint itself, distinct from relinquishing the underlying right or giving permission for the act.
That's subtle but powerful. It suggests the standing to complain is something you hold and can release, separate from the right itself, and exploitation is the inverse. You mentioned that earlier.
Yes, exactly the inverse. The source argues that consensual exploitation, think of some instances of sweatshop labor, or perhaps certain forms of prostitution described in the material shows you can consent to something, thereby arguably waiving certain rights you might have had otherwise, like a right to a minimum wage, or safer conditions, or a right against certain uses of your body.
Okay, you waive the right through consent.
Yet you might still reasonably feel and be seen as wronged by the conduct. The grievance persists despite the waiver of the right. The source suggests we should accept this straightforward appearance, that you can genuinely consent, thereby waiving a right, but still have a legitimate complaint, still be wronged, by the exploitative nature of the treatment you receive within that consensual arrangement.
So the wrong isn't just about the violation of a right you still held, but about the nature of the interaction itself, maybe the power dynamics, the vulnerability that was exploited.
Exactly. It's about the exploitative treatment itself generating a grievance, even post-consent. This really pushes back against that initial Cardozo axiom that you simply can't be wronged unless your specific right was violated.
Okay, this is a lot to think about. So why does this philosophical distinction, this separation of rights and wrongs, actually matter for our everyday understanding of fairness, justice, relationships? Why do we, listening, need to understand this relational dualism?
Well, recognizing this separation is incredibly helpful, I think, for navigating complex issues that get really muddled when we try to force everything into a simple rights violation framework. It offers a way to capture the value of both individual autonomy, which is strongly linked to rights, and that ex ante sphere of control,
Right, my sphere of freedom.
and at the same time our essential membership in a moral community. That second part is more about accountability, interdependence, and the ex post consequences of our actions on others who have a stake in what we do.
It also helps make sense of legal systems, right? Why courts might treat similar harms differently sometimes.
Absolutely. It clarifies why legal doctrines, like standing, who actually gets to bring a case to court, might operate differently depending on the situation. Are you primarily claiming a specific right was violated, focusing on the ex ante duty owed directly to you? Or are you complaining of a wrong that has occurred, focusing on the ex post injury or grievance you suffered because you had a stake? The source notes that standing doctrine and law often reflects this divergence, sometimes allowing claims based more on grievance or stake, even without a direct claim right violation.
And it can clarify contemporary debates that feel stuck sometimes. You mentioned microaggressions earlier.
Yes, that's a great example the source discusses. The argument isn't about settling the debate, but reframing it.
Yeah.
We can recognize the real wrong and injury potentially caused by microaggressions, the exposed grievance rooted in our interdependence, shared social patterns, the cumulative harm of exclusion or disrespect.
Without necessarily having to win an argument about whether there's a prior right to control exactly how others speak or act in all contexts.
Precisely. That ex-ante claim about rights can be problematic, hard to define, maybe overly restrictive, or just shut down dialogue. Separating the concepts allows us to validate the injury and the wrong potentially suffered, the ex post reality, without necessarily getting bogged down in a debate about pre-existing enforceable rights, the ex-ante structure, that might be difficult to apply universally or fairly.
That's a very practical application of this idea. How about environmental ethics? That often feels like a rights problem, who owns the river, etc.
Similarly, understanding environmental destruction as a wronging allows us to capture the harm caused to those who have a stake. Think of fishermen whose livelihoods are destroyed by pollution, or children who will suffer the consequences of climate change decades from now.
People who are clearly harmed but maybe don't own the atmosphere.
Exactly. We can see them as wronged without having to argue that the earth or the fish are strictly owned by us collectively or individually, which is a rights-based framing that can be legally or philosophically complex and sometimes unhelpful. The source argues these are often best understood as third-party wrongs, wrongs suffered by those who have a stake in what is wrongfully done to the natural world. And they are no less grave because they aren't easily framed as a theft of something owned by right.
So this deep dive into the source material really does reveal that our moral landscape is, well, a lot more complex than the simple equation of wrongs equal rights violations. It's definitely not just one-to-one.
Indeed, rights are powerful, essential tools, especially for shaping action and protecting individual spheres of freedom from that ex-ante perspective. They give us control. But wrongings capture a different, equally vital dimension of morality, our accountability to others based on our actions, their standing to complain when harmed or let down, and the nuanced ways we can injure one another based on shared norms, and simply having a stake in each other's actions, often viewed from that ex post perspective after the dust settles. It's this relational dualism.
It seems like understanding this distinction, this relational dualism between rights and wrongs, can help us think more clearly about, well, almost everything, from major legal cases and global issues like the environment, to our most intimate personal relationships and the subtle injuries we might cause or suffer within them, even when no formal rule was broken.
Absolutely. And it encourages us, I think, to look beyond just formal entitlements or clear violations and recognize the diverse ways we are morally connected and accountable to one another in a complex world. It shifts some of the focus from what's strictly prohibited beforehand to what creates a legitimate grievance afterward based on our interconnectedness.
And that leaves us with a provocative thought for you, the listener, to consider. If you can be wronged even when no specific right of yours was strictly violated, what does that tell you about the true sources of injury and obligation in your life, and about your fundamental connection to the people around you?